Hi there, this is Advocate Prashant Kanha. I welcome you to this YouTube channel. In this video, I am going to inform you about the notice under section 35 subsection 3 of the Bharatiya Nagrik Suraksha Sanhita. This section was earlier known as section 41A of the Code of Criminal Procedure. I am sure that you are watching this video only if you have received a notice under section 35 subsection 3 of the Bharatiya Nagrik Suraksha Sanhita. So in next few minutes I am going to inform you about the law, the procedure, the safeguards, the requirements of section 35 subsection 3 and all the precautions that a person who has received such notice can take before appearing before the police officer who has called you, and also answer whether non-appearance or appearance is a choice or is it mandatory. So stay with me. So before proceeding further, I must give you the brief bare text of section 35 subsection 3, which reads as: the police officer shall, in all cases where the arrest of a person is not required under subsection 1 of section 35, issue a notice directing the person against whom a reasonable complaint has been made, or a credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense, to appear before him at such other place as may be specified in the notice. So when you will receive a notice of section 35(3), in that notice the details of the FIR will be mentioned, the FIR number, FIR date, and the sections which have been invoked in that FIR, all that will be mentioned, and it will also be mentioned that where does the police officer wants to be present and answer his queries, and that same shall be stamped and signed by the concerned police officer. It can be served to you either by post, by hand, or even by WhatsApp or email, that means electronically also. So if you receive such a notice, it is a serious concern, but at the same time there is also a sigh of relief, because the first line of the section 35(3) says that where the police officer is of the opinion that arrest of a person is not required, that means he has already made up his mind with the information that is available so far with him, that so far the arrest of the accused person upon whom the notice is being served is not required, but still he has a reasonable complaint, credible information, and a reasonable suspicion that you may have committed such an offense. But the information, evidence, and the suspicion is not of that gravity that he is in a position to arrest you. So to clear that doubt, he may have called you upon to appear before him, and once he interrogates you, then his opinion may change also. Now this section 35 says that even in offenses punishable with less than 7 years of age, 7 years of imprisonment, the police officer can arrest in 6 scenarios. One of which is the police officer has reason to believe on the basis of complaint, in information, or suspicion that such person has committed the said offense. So if you appear before him, his suspicion may increase. And second is the police officer is satisfied that such arrest is necessary. Now there are 5 points under subsection 1 B clause 2 therein: to prevent such person from committing any further offense, for proper investigation of the offense, to prevent such person from causing the evidence of the offense to disappear, to prevent such person from making any inducement, threat or promise to any person acquainted with the facts, that means influencing the witnesses, or as unless such person is arrested, his presence in the court whenever required cannot be ensured. So this section 35(3) leaves a person in a fix, in a limbo, that if he appears then what will happen, and if he does not appear then what happens, because every non-appearance raises the quantum or the gravity of suspicion against you. So it is very much necessary that you appear before the concerned police officer. However, you can get safeguards against the arrest. Now, how to proceed with that? So one of the provision under law is anticipatory bail. You can, as soon as you receive the notice under section 41A, you can approach the concerned session court, that is the additional district judge or the additional session judge or the session judge in your district, not in your district but in the district where the concerned police station falls, where the FIR has been registered. So if you are in, let us say, Lucknow and the FIR has been registered in Ahmedabad, you have to file the anticipatory application before the Ahmedabad court. So in Ahmedabad you can file an anticipatory and you can seek an interim protection from the court with an undertaking that if the interim protection is granted, you shall definitely appear before the concerned police officer, and then you can appear. And at the same time there is another remedy of filing an application under section 482 of the CrPC. But the scope of section 482 CrPC in a notice under section 35(3) is quite limited. Like, you can say the limited grounds are: notice is issued without an FIR, or it is issued by an unauthorized officer, or the notice shows malified intent or harassment. Now let us say that you can prove or demonstrate before the court that the FIR has been registered because of political pressure, or if there was, or if the FIR is totally false and it was registered by using some influence by the other party. So malified has to be demonstrated. Or even if the offense is purely of a civil nature and you can demonstrate that, or the repeated notices are being issued despite full cooperation. These are the grounds, certain grounds which different high courts of this country have entertained while quashing or staying section 41A notice. Even in one of the cases where there was involvement of social media, the court was of the opinion, the High Court was of the opinion that while issuing the section 41A notice, there was no credible information available with the police officer which led him to have a reasonable suspicion on the person to even have issued a notice under section 35 subsection 3. So the police officer has to satisfy itself that why even section 40 this section 35(3) notice should also be issued. So if you have received a notice, you have these safeguards of anticipatory bail or quashing of the same under section 482. However, what would be the strategy or what would be the ground depending on the facts and circumstances of your case has to be determined in each and every case by your legal counsel, and for that you need to consult your counsel and do not solely rely on this video. So that is all with section 35 subsection 3 notice and the safeguards that you can follow while assuring that you comply with this notice. Never try to ignore this notice, because as I said, every ignorance of this notice shall create more suspicion against you, and that can lead into a ground for your arrest. And the more you ignore it, the courts become less lenient to you, towards you or towards your case. Thank you. This was all about the topic.